Today in our Real Estate Documents 101 course, we are going to be reviewing the buyer agency contract. The Real Estate Licensing and Registration Act, also known as RELRA, requires that all real estate licensees and brokers provide a buyer with a buyer agency agreement on the first substantive contact. The buyer may choose not to sign. However, be mindful that without a signed agreement, you do not officially represent the buyer in any fiduciary way. This paragraph reviews the terms of the contract. There is no set or recommended length of a contract, therefore you and your buyer may choose a duration that works for the both of you. You agree that even if your commission is paid by a listing broker, that you will represent the interest of your client, the buyer. The buyer agrees to not enter into any other buyer agency agreement with any other agent until the end of this contract. This contract may end sooner than the designated time if both parties agree, but it may not be extended without the written consent of the buyer. If a buyer enters into an agreement of sale or negotiations on the sale of a property, the contract will end at settlement. Now that you and your client have agreed to the terms of the contract, you will begin to negotiate your fees. Again, there is no set or recommended fee. So you and your buyer must decide what you will be compensated for helping them acquire a piece of property. There are a couple of different ways that your fees could be earned. One is through the purchase of a property. You and your buyer will discuss whether or not you receive a percentage of the sale price or a flat rate fee for helping them acquire and purchase a property. You will also discuss whether or not these numbers change if they purchase a property where the seller was represented by a seller's agent, or whether or not they buy a property in which the seller was not represented by a seller's agent, usually a for sale by owner. You will also discuss what your fee would be if they choose to lease a property. Again, you may choose a percentage or you may choose a flat rate fee. You may also ask your buyers to provide you a fee at the signing of this contract. And then there's also a place for you to say other. This might be consulting services or anything of the sort. Now that you and your buyer have agreed to your fees, it's important to discuss with them how your fee is earned. You will be paid if they enter into an agreement of sale during the term of the contract, despite who found or identified the property. They must pay you if they default on the contract. They may be responsible for paying your fees if they contact a listing agent or owner directly, because that listing agent or owner could then refuse to pay you a commission split. And they'd be responsible to pay your fees if they enter into an agreement of sale after the end of this contract, if you were responsible for bringing about that contract, or if they first saw the property with you and they are not currently under contract with another agent. Paragraphs 3 and 4 explain the difference between dual agency and designated agency. Dual agency is when the broker and the broker's licensees represent both the buyer and the seller in the same transaction. Designated agency would be when the broker represents both the buyer and the seller, but has a different agent, one who is assigned to the seller and one who is assigned to the buyer. Those licensees would represent the interest of their clients and their clients alone. Paragraph 5, you will review your services and those that may be provided to others. While you are representing your buyer's best interest, you are still permitted to provide services to a seller, such as helping them order certificates required for closing, repair services, inspection services, etc. Those would usually be provided to homes that are listed without a listing agent, such as for sale by owners. You may also represent other buyers. You may show the same property to multiple buyers, and it is possible that both buyers or multiple buyers would be interested in purchasing that home. So you may be submitting offers on the same property by different buyers. You will, however, notify your client if there is a conflict of interest, meaning that you have a personal or financial interest in the property and are therefore unable to put their interests before any other. Paragraph 6 explains that this contract is the entire contract. Any agreement made between the licensee and the buyer before this contract was signed is not a part of this contract, and any changes made after this contract is signed need to be done so in writing. In paragraph 7, the buyer agrees to the transfer of this contract, meaning that the broker may transfer the contract if he or she stops doing business, forms a new real estate business, or joins his business with another. Also, the broker agrees that he or she will inform the buyer immediately in writing if this contract is transferred. The buyer agrees to follow all requirements of this contract with the new broker. Paragraph 8 reviews confidentiality. The broker and his or her licensees will maintain the confidentiality of their client, the buyer, unless otherwise permitted by the buyer or required by law. This confidentiality extends beyond the termination of this contract. However, the buyer also realizes that a seller and a seller's representatives may not treat the terms or conditions of any offer as confidential unless there's a confidentiality agreement between the buyer and the seller. Paragraph 9 explains that agents are required to be licensed in the state of Pennsylvania and are considered experts on the marketing of real estate. They are required to disclose any adverse factors that may affect a property that are reasonably apparent to someone with their expertise. Buyers should be advised to consult with an expert on any concern or questions they have that are outside of the agent's realm of expertise. For example, specific conditions or components of a property, or financial or legal advice. Paragraph 10 explains where all deposit money is kept and how it is released. So, a broker or a listing broker will keep all of the deposit money in an escrow account until the sale is completed or an agreement of sale is terminated, or the terms of a prior written agreement between the buyer and the seller have been met. Pennsylvania law prohibits brokers from determining who the deposit money goes to when a settlement has not been reached. They may only release the money if 1, the sale is terminated and there is no dispute over the monies. In that case, both the buyer and the seller must have signed a written agreement. 2, if the broker receives written agreement that is signed by buyer and seller directing the broker how to distribute some or all of the deposit money. 3, according to the terms of a final court order. Or 4, according to the terms of a prior written agreement between the buyer and seller that tells the broker how to distribute the money if there is a dispute between the parties and it is unresolved. Next, you move on to paragraph 11, where you explain the Civil Rights Act. Federal and state law prohibits any seller, broker, or landlord to discriminate on the basis of race, color, religion or religious creed, sex, physical or mental disability, or anybody who's known to associate with an individual who has a disability. Familial status, which applies to children under the age of 18. Age, which is anyone 40 or older. National origin, or the use, handling, or training of a support or guide animal. Paragraph 12 reviews Megan's Law, which refers to legislation that was passed requiring community notification of certain convicted sex offenders. Buyers are encouraged to contact the municipal police department, the state police, or visit www.meganslaw.state.pa.us in order to obtain information relating to the presence of sex offenders near a particular property. Then in paragraph 13, the buyer is reminded that all real estate is sold in its present condition, and it is up to them to determine whether that condition is acceptable. They are advised to carry out inspections to determine the condition of the property and its components. They are also reminded that all information about the property has been provided by the seller and the seller's broker. It has not necessarily been verified by their broker, so they are advised to investigate the accuracy of all property information. Lastly, the buyer is reminded of the Real Estate Recovery Fund, which exists to repay any person who has received a final court ruling against a Pennsylvania real estate licensee because of fraud, misrepresentation, or deceit in a real estate transaction.